Good, thank you.
At the moment I started to record our webinar.
Yes, thank you. Thank you. Good morning, good afternoon, good evening, wherever you are in the world. My name is Piotr Hofmański, and I am a director of Krakow Center for International Criminal Justice. I welcome you cordially to the second open annual lecture organized by our center. We are in the second year of the Krakow Center's activity, but we can already talk about the emerging tradition of organizing annual open lectures delivered by prominent international criminal law experts. Today, we have incredible pleasure of hosting online one of the most outstanding representatives of international law. You say international criminal law and you think Schabas, of course. I would like to thank Professor William Schabas for accepting our invitation to talk about new developments in the law of genocide. I know that the participation in today's event, for which about 300 people are registered, will be a great intellectual feast. I ask Professor Andrzej Światłowski from our center to present the profile of the speaker and then to moderate the discussion after the lecture. Andrzej, you have the floor.
Thank you very much. Professor William Schabas, born 1950, is a Canadian academic specialized in international human rights law and international criminal law. He has published a large body of scholarly work, including more than 20 books in the areas of racial discrimination, genocide, capital punishment, the International Criminal Court, the European Convention of Human Rights, and the International Covenant on Civil and Political Rights. He has also published more than 300 articles in academic journals, primarily in the fields of international human rights law and international criminal law. He is professor of international law at Middlesex University in the United Kingdom and an internationally respected expert on human rights law, genocide, and death penalty. In addition to teaching on the international law, Professor Schabas supervises many doctoral students and also sits on the advisory boards of many journals. Professor Schabas, the floor is yours.
Thank you very much, Andre. I'm very honored to deliver this lecture. I want to thank the director, Professor Dr. Piotr Hofmański, for the invitation to join you and to speak on this fascinating subject of genocide. The last or the most recent judgment by the International Court of Justice dealing with the Genocide Convention was issued only a month ago. This is in a case that had only a very brief existence, filed by Sudan against the United Arab Emirates. It is, by my count, the 19th case to be taken at the International Court of Justice, the 19th contentious case based upon the Genocide Convention. This is an extraordinary number. It may not seem that way to some people, but you need to know that there have not been 200 cases filed at the International Court of Justice since it began its activities in 1946. So 19 cases is approximately 10% of the caseload of the International Court of Justice. And there are, at present, 4 cases, an unprecedented number, based upon the Genocide Convention, pending before the International Court of Justice. I'm going to speak about those 4 a little later in my talk this afternoon. The judgment of a month ago is rather technical, really. Sudan sued the United Arab Emirates accusing it of supporting genocide within Sudan. But the United Arab Emirates had made a reservation to the provision of the Genocide Convention, Article 9, that gives the International Court of Justice jurisdiction. And the judges were virtually unanimous in concluding that there was not what they call prima facie jurisdiction, and so they rejected the application for provisional measures on that basis. But a majority, not a big one, a bare majority of the judges also decided to, in effect, throw the case out because they saw no future for Sudan's argument that the reservation of the United Arab Emirates was invalid or contrary to the object and purpose of the convention. It's interesting to read the various dissenting judges in the case because they in particular highlight the importance of the Genocide Convention for the court. 6 of the judges, including one ad hoc judge, signed an opinion where they said, and I quote, "There has been growing recognition of the importance of state responsibility for genocide, not simply individual responsibility." And this is perhaps a modest signal of the attention that they are giving to the 4 pending cases, the 4 that remain before the court. Perhaps even more significant were the comments of the Mexican judge, Judge Gómez Robledo. And he spoke about the International Court of Justice as being, and I quote, "the guardian of this legal instrument." And he said that the court's role as a guardian of the Genocide Convention, he said, is more crucial than ever. And I think for various reasons, which I will now elaborate on, the Genocide Convention is in a way in a bit of a renaissance. It's a convention now that is almost 80 years old, but it is being reinvigorated by judges, but perhaps even more importantly by states, parties to the convention, members of the United Nations, and I should say observer states of the United Nations as well. But if I may, before going further, let me just make a few comments about our host state, Poland. I'm very happy to do this online, although I would have loved a pretext to visit Poland once again. Poland played a very extraordinary role in the development of the law of genocide. The first important legal instrument dealing with genocide is not the convention, but the General Assembly resolution of 1946. Often overlooked because perhaps it's just seen as something that initiated the convention or provoked the drafting and then the adoption of the convention. But in my view, it's an important document that stands on its own, also because it's a clear recognition by the United Nations General Assembly that genocide existed as a crime under international law in December 1946, when the resolution was adopted, but that it also existed under international law prior to December 1946, because the General Assembly doesn't legislate, it doesn't create a crime, but it's a declaratory body, and it was declaring that genocide already existed as a crime under international law. Poland, of course, was a founding member of the United Nations, and it was a very active participant in the debates that led to the adoption of this resolution on the 11th of December, 1946. The resolution, and I think this is also significant to the history of the convention, was proposed not by states of the global north, but by the relatively limited number of states from the global south, including India, Cuba, and Panama. After the resolution was adopted, of course, it called for the adoption or the negotiation of a convention. And the next major step in the drafting of the Genocide Convention was the convening of an ad hoc committee by the Economic and Social Council in early 1948. It was a 7-member committee. It had 4 of the 5 permanent members of the Security Council recommended. The United Kingdom did not join the committee. It could well have done so had it wished to, but it was lukewarm then about the Genocide Convention. And so the 7-member committee consisted of the United States, the Soviet Union, France, and China. And then 3 other countries were added, Lebanon, Poland, and, oh, it's escaped my mind now, the third one, but there were Lebanon and Poland. There was a third state that was added to the group. So 7 of them all together. And so there, Poland played a very, very significant role in creating what became the draft that then went to the United Nations General Assembly late in 1948 for the final negotiations. Poland acceded to the Genocide Convention in November of 1950 with a reservation to Article 9, similar to the reservation that the United Arab Emirates has made to the convention. But like many other states, Poland withdrew its reservation to Article 9. It did so in 1997. So this is Poland's connection with the legal instruments. But of course, Poland was also the country, I think, where in the last century or so has the largest number of victims of genocide, because of course it was on Polish territory where the German extermination camps were located in the main. I'm not going to try and sell my book any more than this, but I want to show you the latest edition of my book on genocide, which was published by Cambridge University Press only a few weeks ago. And we put on the cover a photograph that comes from the Auschwitz-Birkenau camp of a well-known photograph of the shoes of the victims of one of the great genocides of the 20th century. And then finally, we can't talk about the origins of the convention and Poland's connection without talking about Raphael Lemkin, the man who invented the word in 1944 in his book Axis Rule in Occupied Europe, but then campaigned very actively for the adoption of the convention and the resolution in 1946. It was Lemkin who promoted the idea of the 1946 resolution of the General Assembly. He wrote the draft resolution. He convinced the 3 ambassadors from India, Panama, and Cuba to support it and to present it in the General Assembly. He is reported to have written the speech for the Cuban ambassador who stood up in the 6th Committee of the General Assembly in November of 1946 to propose the resolution. And in the resolution, in the speech that the ambassador delivered, the Cuban ambassador, these were Lemkin's words, he said that the purpose of codifying genocide, of recognizing genocide as an international crime, was to fix or to repair the shortcoming of Nuremberg. The idea of, first of all, the resolution, and then the convention in 1948 was to address the failure of Nuremberg to deal with peacetime genocide. Of course, the Nuremberg trial didn't, in a technical sense, prosecute the crime of genocide. It prosecuted what we know as genocide under the heading of crimes against humanity. But the real difficulty of the International Military Tribunal was and this is in its charter, obviously enough. We can see evidence of this in the records of the London Conference, where the charter was adopted, and of course in the judgment of the judges who decided not to hold the defendants guilty of any crime under the charter for acts perpetrated before the outbreak of the war in 1939. And this was, in effect, confirmation that the atrocity crime, whether labeled as crimes against humanity or called more colloquially at the time, genocide, was a crime punishable only when it had a link to the war. And the records of the drafting show that at the root of this was an anxiety expressed by the American delegate, Robert Jackson, but by the other participants in the London conference, about the idea that they would be held responsible themselves for crimes of racial discrimination, systematic racial discrimination perpetrated on their own territory or in the territories for which they were responsible. And so the big addition, and we see this in the Genocide Convention in Article 1, adopted in 1948, is that it's a crime that can be committed not only in time of war, but in time of peace. I'm not going to try to go through the history of genocide and how it was dealt with in the several decades that followed. I'm going to do a fast forward to get to the 1990s. All I can say about that period is that there were periodic attempts in the 1950s, particularly in the 60s and 70s, to bring the Genocide Convention and the crime of genocide to bear on such acts as the apartheid regime that prevailed in South Africa and the racist regimes that existed in other countries of Southern Africa, the Portuguese colonies, Southern Rhodesia, notably. So in the 1990s, there was a period of really phenomenal development of international criminal law, both institutionally, the creation of the ad hoc tribunals for the former Yugoslavia and for Rwanda, and then finally the International Criminal Court with the adoption of the Rome Statute in 1998. But there was also, of course, a phenomenal development in a substantive sense, in that the concepts of international crimes that had been in effect codified and addressed judicially in the 1940s were modernized. They were dramatically expanded. We're talking about three basic categories that we inherit from the 1940s: war crimes, crimes against humanity, and genocide. War crimes until the 1990s were widely considered to be crimes that could only be committed in international armed conflict. And so in the 1990s, first by a bold judgment of the appeals chamber of the International Criminal Tribunal for the former Yugoslavia, judges declared that war crimes could be committed under international law, under general international law, in a non-international armed conflict. And that was, of course, then confirmed in Article 8 of the Rome Statute. The other companion development, if you want, was a recognition that crimes against humanity were no longer confined to atrocities committed in association with an international armed conflict or an aggressive war, but could in fact be committed in time of peace as well as in time of war. It was this problem, as I said a few minutes ago, that provoked Raphael Lemkin to propose the resolution on genocide, and then to participate in the development of the Convention on Genocide, which clarified that genocide, which is really very easily understood as a category, a subcategory, if you want, of crimes against humanity, but one that could be committed in time of peace. And with this expansion in these two categories of international law, the pressure to change the Genocide Convention was relaxed. In the course of those years, from the adoption of the convention in 1948 until half a century later, the adoption of the Rome Statute, there had been regular calls to amend the Genocide Convention because its definition was seen as being too narrow. The genocide definition in Article 2 of the Convention said it applied to national, ethnic, racial, and religious groups. And there were calls that it should be expanded to include political groups, gender-based groups, and so on. There was a whole list of them, and some of that was actually picked up in national legislation. But in the 1990s, there was no great impetus to amend the Genocide Convention or to amend the definition of genocide that went into the Rome Statute in order to address these concerns and these calls for amendment. There were also calls for the Genocide Convention to be enlarged to cover a wider range of acts, because it was widely understood that the definition in the convention was confined to physical destruction of the group. We know that when it was being adopted in 1948, there was also there was a list that the drafters considered of acts of cultural genocide, but there were very deliberate decisions taken in 1948 in the Sixth Committee of the General Assembly in particular, but also in the ad hoc committee, to exclude cultural genocide from the scope of genocide, much, by the way, to the dissatisfaction and displeasure of Raphael Lemkin. So the 1990s was, in a way, a golden opportunity to amend the genocide definition as well as the definitions of crimes against humanity and war crimes. But states, we're talking here now about the authors of this legislation, states, when they assembled at the Rome Conference to adopt the Rome Statute, showed very little interest, almost none at all, in amending the crime of genocide. They treated it more as a monument to the past rather than a dynamic notion for the present and the future. Well, the Rome Statute was adopted as the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda were really just getting started. There had only been a handful of decisions. There was very little case law when the Rome Statute was adopted. But very soon, both tribunals started to address the definition of genocide. I'm not going to say much about the Rwanda tribunal. The case in Rwanda was so straightforward and so clear a case of genocide that, in a way, its case law is of less interest in terms of the understanding the contours of genocide than the case law of the International Criminal Tribunal for the former Yugoslavia, because it was there that we had to go up to the boundaries between genocide and less severe forms of atrocity, often going under the label of ethnic cleansing. And within a year or so of the adoption of the Rome Statute in 1948, there were significant decisions by the judges of the International Criminal Tribunal for the former Yugoslavia, pointing to a narrow approach to the definition of genocide. They were, I think, in a way reflecting the same conservative approach that states appeared to adopt when given the opportunity to amend the Genocide Convention at the Rome Conference and when they chose not to do so. I also think, it's important to consider why they might have done this. And I think that a part of their own reluctance to apply the definition of genocide to the situation in the former Yugoslavia was because they could very comfortably, in a legal sense, hold that the various violations were crimes against humanity. This was not a question of deciding that it was genocide or nothing, of declaring that they don't have jurisdiction if something is not genocide. It was simply a case of trying to adjudicate a line between crimes against the crime of genocide, which would require the intent to physically destroy the group, and crimes against humanity, which would cover acts falling short of physical destruction, which would cover more groups, which would cover even situations of atrocity that didn't involve groups at all, and that would not require physical extermination, but could apply to cultural attacks on the group. So all of the issues that had been viewed as gaps or shortcomings in the definition of genocide were essentially repaired by this broader notion of crimes against humanity, especially bearing in mind that as of the 1990s, it was clear that crimes against humanity applied in peacetime. Well, the case law of the Yugoslavia Tribunal was very influential at the International Court of Justice. There were two important cases that were proceeding they were filed during the 1990s, and one of them went to a final judgment in 2007. This is the case of Bosnia versus Serbia. And the second went to a final judgment of the International Court of Justice in 2015. This was Croatia versus Serbia. In both of those cases, essentially, the claim of genocide in a sense applying to the conflict failed. In the Yugoslavia, in the case dealing with Bosnia, the case filed by Bosnia, there was one bright spot in the decision in that the court there also developed a doctrine concerning the prevention of genocide, which was a very radical conclusion, in my opinion. Amongst other things, they held that a state could be responsible for failing to prevent genocide in another state, an extraterritorial obligation for which we have little or nothing in treaty law to compare with it. But the judges, and this is not the only time I've seen this happen in international law, where judges actually go further than you would ever get with a treaty, no matter how creative and innovative states appeared to be. So at the International Court of Justice, in contrast with the International Criminal Tribunal for the former Yugoslavia, they did not have the luxury of concluding that if a case was not genocide in the strict sense, that it was crimes against humanity. In those two judgments, the court was a binary issue. They could either rule that genocide was committed, or they could rule that they were without jurisdiction, because the jurisdiction of the court was based exclusively on the Genocide Convention. And I wonder if this contributed, perhaps, if the Yugoslavia Tribunal's strict interpretation of the crime of genocide, which, as I say, may well have been influenced by the fact that it had the luxury of making a ruling of responsibility for crimes against humanity. It was awkward to transpose that to the context of the International Court of Justice, which did not have that option, and which essentially had to dismiss a case if it didn't adopt that interpretation. This is history now. This is what has happened at the International Court of Justice, and I think that one, looking at this in 2015, after the judgment of the International Court of Justice in the Croatia versus Serbia case, I think it would have been reasonable to say this convention has passed its sell-by date. This is a convention that's not going to be useful or applicable at the International Court of Justice. The standards are too high. The rules are interpreted too strictly. The conditions for proving genocidal intent are simply too severe and too strict as imposed by the court to make the convention of any practical use. And I can tell you, having followed these issues of genocide at the court, at the ad hoc tribunals, and elsewhere for more than 30 years, in 2015, I was of the view that this is the end of the road for the Genocide Convention at the International Court of Justice. Maybe it would be applied, it would have a very valid existence in other international criminal tribunals based on individual responsibility and before domestic courts, but not on the basis of state responsibility. And I must tell you that I misjudged that myself. I completely misjudged it, because what we've seen in the last half dozen years is a great enthusiasm, mainly from states, not from the court itself, an enthusiasm for reviving, for energizing the Genocide Convention and for giving it a role, a vital role in the international legal order. I say this is really the work of states because, you know, those of us who work at the International Criminal Court, who work around the international criminal justice institutions, we're used to the idea that the initiative for addressing different situations and questions and so on comes from the prosecutor. The judges too, to some extent, but ultimately it's the prosecutor who decides where the prosecutions will take place and how much will be invested in terms of resources in one situation as opposed to another. But in the field of state responsibility at the International Court of Justice, this is an agenda that's entirely controlled by states. And so we see this incredible interest of states in the Genocide Convention in recent years. So the first sign of it is the first of the recent cases to be filed, which is the case filed by the Gambia against Myanmar. That case, I think this is all quite public. There's no mystery about it. This was a case that was taken by the Gambia, but the Gambia was acting in a sense on behalf of the Organization of the Islamic Conference, a 57-member state organization. And it had discussed within the OIC the importance of taking the case against Myanmar, and the Gambia stepped forward and said, we'll do it. But to some extent, we have to view that case as being, it was kind of a collective effort on behalf of many states in the Organization of the Islamic Conference, who placed some trust in the International Court of Justice and thought this is the place to litigate this issue of genocide. The other feature of the case that's important, and we'll see that it's also a feature of two of the three other cases dealing with genocide, is that this was a case that was erga omnes. It was a case that was filed by the Gambia acting in the collective interest of the integrity of international law and accountability, rather than acting as an injured state, which is the case with most of the 200 cases that have come before the International Court of Justice. It's true there's a precedent for an erga omnes case a little earlier this is the case between Belgium and Senegal, but really Belgium had been having a quarrel with Senegal about this for some time, and although it was recognized that it was acting erga omnes, it also could claim that in some sense it was an injured state. But this was not the case with the Gambia. The other thing about the case filed by the Gambia against Myanmar is that there have been a significant number of interventions in the case by other interested states. I think we're now probably at around 8 or 9 interventions in the case by states. This too is unprecedented. Until 3 years ago, really, there had been almost no interventions ever in the history of the International Court of Justice in any cases. There are a few examples dealing with border issues and so on, but certainly not in an erga omnes context where states are intervening in a case. In these genocide cases, they intervene sometimes to take sides with one side or with one side or the other in the case. But more generally, they fit into this paradigm of the erga omnes intervention, and it's another feature that's unusual, unprecedented, and extraordinary. The next case to be filed is the case taken by Ukraine against Russia. It's a bit of an anomaly because unlike the other cases, unlike essentially all of the other cases on genocide that have been taken by before the International Court of Justice, it's not charging the other side with committing genocide. It's charging the other side with making a false charge or allegation of genocide. And in the case of Ukraine, there was a part 2 of this, using that false charge to justify its invasion, its armed attack on Ukraine in February of 2022. And So that case has attracted something like 34, I think, interventions. Again, there, a huge number of cases have intervened. Some of them intervened on the issue of the preliminary issues, jurisdiction and admissibility, but some of them have intervened distinctly on the issue of the merits of the case. Now, that case had a strange twist when, after it was filed, it seemed at the time like an extremely creative and original approach by Ukraine, by the lawyers of Ukraine, and one that had was useful in terms of getting the invasion of Ukraine before the court promptly within days following the invasion, and getting the court to issue a provisional measures order against Russia. I think, though, that following that, it went downhill a bit in that Russia challenged the fact that Ukraine was really using the Genocide Convention as an indirect way of litigating the issue of aggression. And in a judgment issued in 2024, the court essentially agreed with Russia. And throughout that half of the case, leaving the other half of the case saying that Ukraine was still free to pursue its case, to have the court make a declaration that it did not commit genocide in answer to Russia's charge that it was committing genocide. And that case took another twist late last year when Russia filed its own counter memorial, which is apparently accompanied by its own counterclaim. This is a measure that states take, as they do in civil proceedings, which you'll all be familiar with in law school if you haven't practiced law, when someone is sued and they say, well, if we did this to you, you did this to us. And it appears that's what Russia's done. I can't be sure, because much of the proceedings at the International Court of Justice are shrouded in secrecy until the oral hearing begins. But Russia did announce, and this is public, that it was filing a counterclaim. And I would suspect that what Russia's counterclaim is claiming that if it violated the Genocide Convention by making a false charge against Ukraine of genocide, that Ukraine did the same in making a false charge against Russia of genocide. My own view is that neither side has a very strong argument that the other side committed genocide. We'll have to await how this case plays out eventually. But the big case, of course, which is now almost ready, I think, for an oral hearing, is the Myanmar case. It was filed at the end of 2019. The memorials and the counter memorials have all been exchanged. I think the last written proceedings were due in December of 2024. So we can probably expect the court sometime soon to announce an oral hearing. It might be next year in 2026, and that would mean we could look towards a judgment in the case perhaps at the end of 2026 or in 2027. It's impossible to be sure about this. And then we have the two cases now that are the most celebrated in a way, certainly the one filed by South Africa against Israel at the end of December in 2023, and then the case filed in March by Nicaragua against Germany. The South Africa case managed to find, you might say, a chink in the legal armor of Israel, its imperviousness to international law or to international adjudication, because Israel, although it has not accepted the general jurisdiction of the International Court of Justice, has accepted the Genocide Convention without a reservation to Article 9. And it was on this basis that the case was taken by South Africa, and South Africa, to global attention really, because this was all broadcast and very public, in late January of 2024, obtained a a provisional measures order against Israel that was followed in the subsequent months by other provisional measures orders. That case now is proceeding and has a significant number of interventions in that case. I think we're up to 12 or 13 interventions in that case. The court has not yet ruled on the admissibility, on the status of the interventions. But, when you combine that with the interventions in the Ukraine case and the interventions in the Myanmar case, we have somewhere around 50 states who've intervened in these proceedings. And this has never before been seen in The Hague at the International Court of Justice. In the Ukraine case, most of the interventions, I guess all of them really, are in effect supportive of Ukraine. In the South African case, the interventions are by and large supportive of South Africa. Just in terms of the progress of that case, South Africa filed its memorial late last year. Israel has obtained now some extension of time to file its counter memorial, and I think it's due in the beginning of 2026, and then there'll be more exchanges of proceedings. So we're probably not going to see an oral hearing in that case for another 2 or 3 years. And then finally, the case filed by Nicaragua against Germany, which is not charging Germany with genocide, but with charging Germany with complicity in genocide by providing support, particularly weapons, to Israel, and also by its failure to prevent genocide, this creative, bold doctrine developed by the International Court of Justice in the Bosnia versus Serbia case in 2007, but which has not really been applied. It certainly has not been applied by a court since then. But the argument is to the effect that states that are influential with a state that is responsible for genocide can be held responsible by their failure to use all of their influence in a lawful manner to try and prevent genocide. And so that case arises, those issues arise in the case against Germany. And the case against Germany also is based not only on the Genocide Convention, but on customary law, the customary law of genocide, the customary law of war crimes, and of course the major international humanitarian law legal instruments. So altogether then, when we add them all up, the interventions, the states that have applied in these cases, we have, and I'm not going to add all the states in the Organization of the Islamic Conference, but we're talking now of something like 60 states that in some way or another are engaged in this judicial debate about the Genocide Convention. And they're all expecting the Genocide Convention to do something, to be effective. So what form is this going to take? I don't think that the issue of enlarging the categories of groups that are protected by the convention right now, national, ethnic, racial, or religious, consecrated in the Genocide Convention, and there have been calls historically for those to be enlarged, but I don't think that there's much traction for that. It's certainly, this is not an issue that seems to be important in any respect in any of these cases. I also think that the cultural genocide idea, the idea that the punishable acts of genocide should be extended and the notion of destruction should include not only the physical destruction of the group, but perhaps attacks on the existence of the group that fall short of physical destruction, that is cultural, what we call cultural genocide. This too is not really at the heart of any of these applications, and I don't see it. I don't see any space right now for that to develop. But where I think there is a great potential, and where I think it's quite reasonable to expect there to be some development, is in the area of the proof of genocidal intent. And this is an area where the court has been has been the International Court of Justice, but also the Yugoslavia Tribunal, very, very cautious, mainly because the cases that it dealt with, it felt that the proof was the proof of genocidal intent was based essentially on circumstantial evidence rather than on direct evidence. And I think that my own assessment is that, particularly in the case of South Africa versus Israel, we have a lot of what I would call direct evidence. We have many factors that point towards that indicate direct evidence of judicial intent, starting with some of the very notorious statements by Israeli leaders. Everybody remembers the statement by Yoav Gallant in October of 2023, when he said that that Gaza would be cut off, no electricity, no food, no potable water, no medical care. And there have been statements along those lines subsequently by other leaders in Israel. So coming at the highest level, in some of the other cases, it's been more what I'd call soldier talk. It tends to be racist statements picked up on Twitter and so on by participants, rather than messages that appear to be really direct incitement. We had some of this in Rwanda, and of course we had plenty of it in Nazi Germany. But it seems to me that there's certainly serious evidence of this in the case against Israel filed by South Africa. The interventions are interesting, and there was a fascinating intervention filed in late 2023 by 6 Western states acting on behalf of the Gambia against Myanmar in that case. So the states were Canada, Denmark, the Netherlands, France, the United Kingdom, and Germany. And they agreed on a joint intervention that in effect called for a broader and more flexible approach to the proof of genocide. They said that in assessing genocidal intent, there were important features of a campaign or of an attack that pointed towards genocidal intent, and that needed to be emphasized by courts in the assessment of them. One of them was victimization of children, was singled out there as one of those features that they thought was important. Another one was forced displacement, so not necessarily deportation, but forced displacement within the territory. And they highlighted these features of it, also sexual and gender-based violence. These were elements that would be, of course, strengthen and enhance the case of the Gambia against Myanmar in terms of the treatment of the Rohingyas. But they were also features that, of course, they did not know it at the time when they wrote and filed this intervention, but that have become clear are also features of Israel's conduct in Gaza. And I think this is, of course, one of the great great aspects of this judicial attention to these conflicts and the popularity of the International Court of Justice. And it's with this idea I just want to conclude. The International Court of Justice has become, in many respects, a human rights court. It has these cases under the Genocide Convention, 4 active cases under the Genocide Convention, but it also has active cases under the Racial Discrimination Convention, under the Torture Convention, and there's a case that's promised, it hasn't been filed yet, under the Convention for the Elimination of Discrimination Against Women. There are also the advisory opinions that they certainly reflect a wide consensus of states, because they require a strong majority in the General Assembly to get them before the court. And we've had more of these in the last few years, essentially all of them dealing with human rights issues, than we've seen for many, many decades, with a case on the right to strike, a case on climate change with a strong human rights component, and 2 cases dealing with the situation in Palestine and in Israel. And what's going on here? Well, what this seems to me shows is the the search by states for judicial answers, for law to address the great crises of the day, be it climate change, or, of course, the situation in Gaza and more generally in the Middle East. That states are frustrated in the political bodies which are the home of hypocrisy, of double standards, and they seek to put questions before a court and say, we can't fix this. We can't fix this in the Human Rights Council. We can't fix this in the Security Council. We can't fix it in the General Assembly. But maybe with some guidance from the International Court of Justice, we can move these pieces on the chessboard forward a little bit. And in my sense, that's what's going on, and I think it's an extremely welcome development. I believe that the judges at the court sense this. I think that's why we've seen these recent statements that I mentioned at the very beginning of my talk today, and they have performed, I think, very impressively with their rulings in a range of decisions in the last few years. They've shown themselves able to build strong majorities, although the judges there, all of them have different views, and sometimes they express them in individual opinions. But they are able, I think, very, very, very admirably, to come together and to reach some compromises amongst themselves that give added strength to their rulings and that have made the court such a vital institution. It's a fragile existence. It's something that there could be a misstep and it would destroy it. But for the present, they are contributing to the strength of this important body. They are contributing also to the revitalization. I'm speaking a little too prematurely, perhaps, because they haven't done it yet. But I am anticipating it, and I think that it's quite possible and maybe even likely that they are going to, inject new oxygen into the Genocide Convention of 1948 and to transform it from being a bit of a relic of the past into an important instrument for the future. And with that, I'm going to conclude, and I will look forward to exchanges with you with your questions and comments. Thank you very much.
Thank you very much, Professor, for the extremely instructive and inspiring lecture we had the opportunity to listen to. Dear participants, please be advised that the chat window is available to everybody of you. So please feel free to share your comments and of course, ask the questions via the chat window. Same time, I would like to invite you and encourage you also to ask the questions directly and please let us know that you are willing to do it by raising your hand this way, like I do it now. And I can see that already 2 participants are actually wishing to take the floor and share some comments, interventions, or maybe questions. Let me omit all the academic titles, etc., for the sake of simplicity. So according to the order, according to the numbers we can see next to the yellow hands, first participants, please ask your question. I can see, yeah.
May I? Can I ask?
Okay.
Would it be fine? Thank you very much for such good diving into important questions for me, for example, and it was very interesting, really. I would like to ask, actually, you mentioned very shortly, so to move forward like this piece a little bit, as I understood, regarding genocide, regarding intent, regarding these international crimes. So you mentioned the importance of International Court of Justice. And on the other hand, what do you think about this, in more global sense, about this influence of International Court of Justice and European Court? Because on one hand, many things are already like considered by European Court, and there are many specific positions regarding what we should consider under genocide intent. And even, as I know, there was one decision, then European Court decided that in that specific case, it was allowed, it was like appropriate to consider genocide intent not so like to consider in a broader context, taking into account not only specific groups which are indicated in genocide convention, but also political groups in that specific context. So how it's possible to consider both courts as the courts which could provide development of international criminal law, well, in that regard, could it be like considered as supporting each point of view, or otherwise these points of view could be totally different? Because to consider genocide intent like in connection with political groups as protected group is a little bit specific context. Well, if it's clear, thank you very much. If my question is clear, thank you very much.
Excuse me, Professor. So as our webinar is being recorded, I would like to ask everybody who is asking the question to start with your name and, if necessary, with your affiliation. And second point is that that the actual information is that you can ask your question in the questions and answers section rather than a chat. So it was my mistake. Please forgive me. You can ask parallelly. You can ask your question.
Would you like me to write it down into the chat, or it's fine that as you wish?
I think I got the gist of Svetlana's question. I don't think you need to write it. It's Svetlana, isn't it?
Yes, thank you very much. I'm very sorry. I am actually, on one hand, I'm just about me. I'm actually a little bit like, well, I'm from Ukrainian academic, and at this moment, I'm teaching at Karlsruhe. PhD candidate. Okay, thank you very much.
Okay. Andrei, shall I answer that question now?
Yes, thank you very much.
Yes, of course.
Yeah, well, the European Court has had actually very limited activity when it comes to genocide. Most of its treatment, and I think this is a general rule about international criminal law, concerns Article 7, the principle of legality, and assessing whether crimes under international law, what the status of them is, and whether prosecutions are legitimate or not. I think the case you're referring to is a Vasiliauskas versus Lithuania case. I was counseled in Lithuania in that case, which dealt with Lithuania's attempt to broaden the definition of genocide with its own legislation, extending it to political groups. And there's nothing wrong with doing that. You're not going to have a problem under the European Convention unless you try to prosecute people retroactively. So Lithuania's legislation was adopted in the 1990s, and then it was applied with respect to offenders from the 1950s. who were essentially Soviet agents or officials who were attacking Lithuanian nationalists. So in that case, I argued for Lithuania. I referred to the General Assembly resolution of 1946, which spoke of political groups, even though the Genocide Convention does not. And I said this is evidence that this was a crime, that was a broader understanding of genocide that was accessible and that was recognized under international law. Well, as I say, I managed to convince 8 of the judges of the Grand Chamber to uphold Lithuania's position. Unfortunately, the Grand Chamber has 17 judges, so 8 out of 17 is not quite enough. And that was later repaired by when Lithuania changed its prosecuting policy slightly. So but the court there was, it's part of its case law under Article 7. We could have a whole conference on that alone as well. I'm not going to get into that.
Okay, thank you very much. Just one short question. Additionally, would it be possible to contact you by email? I'm very sorry if the question is not appropriate.
People contact me by email all the time, and I answer all the time as well. So you're most welcome. Everybody here is most welcome to write me if you wish.
Okay, thank you very much.
Okay, so let me ask the person who was the first one to inform us about the readiness to ask the question. And afterwards, I think it would be a good idea to switch to questions and answers section because I can see already 5 questions placed there. So Mr. or Mrs. Sima Nouri, please ask the question.
Okay, thank you so much. I am Sima Nouri. I am original Hazara from Afghanistan, but live in Norway, and I am woman activist. You're excellently as a former president of the International Criminal Court. How do you assess the ongoing and systematic persecution of the Hazara community in Afghanistan, including target killings, forced displacement, land confiscation, and denial of education? In your expert view, does this situation meet the threshold of genocide as defined by the Rome Statute? And what are they are the key legal or political observative that how prevent international persecution or investigation for far. If you have some information about the Hazara genocide, you can please. Thank you.
Thank you. I'm not sure if was this addressed to Professor Hofmansky or to myself?
About you, because we are sent it from the World Hazara Council in 2015.
Okay.
And 400 documents from the Hazara genocide to ICC court.
Okay, I don't know enough about the facts of the situation in Afghanistan to give you a useful opinion on whether or not we can refer to the charge of genocide. One of the concerns, of course, that I think is going to weigh heavily on the International Court of Justice, as it will on the judges of the International Criminal Court as well, if they actually deal with genocide cases, is the perceived danger that it will lose its usefulness and efficiency and effectiveness if it is used to describe everything. It's a there are for every one case that fits the legal definition of genocide, there are many where there are allegations and where the legal qualification isn't really appropriate. And one of the problems there that's, I think, unfortunately very misunderstood among victim groups is that conclusion that maybe this is not properly described as genocide is often accompanied by a statement that it is very clearly covered by crimes against humanity. And there is a common, but I think incorrect perception that somehow describing something as crimes against humanity is somehow inadequate or insignificant. In the Rome Statute of the International Criminal Court, there is no hierarchy of the categories of crimes, and we can have cases of crimes against humanity that will be more severe and more outrageous than crimes of genocide, and the same for war crimes. So, as I say, I'm making that general comment, and I just feel that I'm not in a position to make a statement about the situation in Afghanistan.
Okay, thank you so much. Just a last question. Can we have a formal meeting, in the future, and we are talking more about the Hazara genocide and send more documents about to ICC?
Why don't you write me? Why don't you send me a message and we can exchange on this? Okay.
Okay, thank you so much.
Thank you. My proposal is now to switch to the question and answer section. Professor, can you see the questions already present there? I can see 5 questions 24 minutes ago. Bismillah Taban asked the first question to be seen in this section. Can you see it?
Yes, but it's the last one on my list. It doesn't matter.
Because it's a reversed order, I think, because it starts from 8 minutes, then 11, and the last one is 24.
Oh, you're right.
So I understand it's the reversed order.
Yes, okay. Oh, but this is the same question. It's the same question as I was just asked about the Hazaras in Afghanistan. And so I'm afraid it will be the same answer. The next question.
The next question comes from Susanna, yes, and I can see that 2 participants, I understand, joined this question. Because I can see the
the question is,
yeah.
Do you see any chance the prosecutor of the ICC would change the charge against Vladimir Putin from war crimes to genocide? Well, I don't think, I said this before, I don't think that it's very useful to speculate on the application of the notion of genocide to the conflict in Ukraine. There are a lot of terrible things happening there. There are a lot of crimes being committed, but I think genocide is probably far from that. So, of course, it's possible that the prosecutor could change the charges. It's also possible that the judges can do it under certain circumstances. You know, our problem, you ask about the prosecutor of the ICC, our problem is we don't have one right now. He's on a leave, and the court is really in a situation where it's quite severely handicapped because of this what is ultimately a disciplinary situation quite removed from any of the political challenges that face the International Criminal Court. This is a question from Abdul Hadi Haidari, but it's also about the Hazaras in Afghanistan, and I can only give you the same answer. And then from Darcy Senft, do you believe that there is room for arguing that actions by states such as the USA in withholding, for example, intelligence from Ukraine, or stopping the provision of military aid, along with other similar actions, amounts to evidence of state failure to prevent genocide in light of the ICJ's guidance in the Bosnian case? Well, Darcy, I think the first question again, and I'm going to repeat myself slightly, is that I don't really think we're talking about genocide when we're talking about Ukraine. We're talking about a war of aggression. We're talking about violations of the laws and customs of war. We may be talking also about crimes against humanity, but we're not talking about genocide. Um, and there, I don't know that any case can be made that a war crime is being committed by the reduction or the failure to provide military aid. I wouldn't know where that fits in. So I guess my answer is basically no to your question. Um, and then finally from Kaya Kowalska. Dear Professor, I have a question about the relation between genocide and crime of genocide. Do we know from the past the cases where finding states responsible for genocide, that is based on official statements, had an impact on individual criminal responsibility for the crime of genocide? Let's say the ICJ would find state X responsible for breach of the convention. That would be a legal basis for the ICC to pursue actions against individuals. Well, yes, of course, here we're facing this problem of, we could say, maybe fragmentation is a word that was used in the past to speak about the relationships between different levels, different categories of international tribunals. With genocide, it's a particularly vexing problem because we have two parallel notions in the Genocide Convention of state responsibility and of individual criminal liability. If one goes back, and I spent a lot of time poring over the debates when the Genocide Convention was being adopted in 1947 and 1948, and I don't think that there's any clarity about what the states who adopted the Genocide Convention thought they were doing. There were many who saw the Genocide Convention as essentially a treaty like a suppression treaty of criminal law, where it was defining a crime and then governing the prosecution of that crime by domestic criminal courts. And I think that was a strong current when it was being adopted. And, we see that in the definition of genocide in Article 2, which talks about intent. And there were others who took the view, some took the view that this was all about state responsibility. But I don't think they prevailed, but they were present and they were part of it. And of course, the International Court of Justice in the Bosnia versus Serbia case made it clear that the Genocide Convention was also an instrument dealing with state responsibility, in that a state violated the convention not only by failing in its obligations to punish genocide, but that it could also actually commit genocide. And that has led to some of the challenges we have with the definition of genocide, because that definition, which refers to the intent, is hard to apply to state responsibility, because states don't have intents. Intent is a psychological notion about individuals, and it would have been better there to do something that we do in the Rome Statute when we get to crimes against humanity, is to talk about policy. So some of this judges can fix. I mean, this is one of the part of the challenge for the courts, and they're still doing it, is to apply and interpret these instruments. Principally, now we're talking about the Genocide Convention, but it will apply, and it's going to apply in the future, because we have a Crimes Against Humanity Convention being prepared, so that we can in some way reconcile these things. What would be very undesirable would be a situation where you have a criminal court deciding that there's no genocide, and a state responsibility court like the ICJ deciding the contrary, or vice versa. But that could happen, and there's no solution to that problem short of creating a global government, and we're not there yet. I thought that the International Court of Justice, in its Bosnia decision, which was the court did a very, very admirable job in trying to ensure that there wasn't any great tension between the case law of the Yugoslavia Tribunal and the and the decision that it had to adopt. It confronted and then I think addressed in a very elegant way this issue of fragmentation. But you know, something that was present in the Bosnia and the Croatia judgments that we don't have in any of the cases that are pending before the court is that the evidentiary issues had been very, very thoroughly litigated by criminal courts in lengthy trials with experienced judges and experienced counsel, with evidence that was tested by cross-examination and assessed according to a very high standard, the standard of proof of reasonable, beyond reasonable doubt. And in the 2007 decision, and again in 2015 in the Croatia decision, the ICJ could rely upon that material. We don't have that. We don't have it for Myanmar. We don't have it for Israel, and it's not going to be. Well, this is an unknown in these cases, is the evidentiary issues, because of the fact that we don't have the quality of the evidence that we had in those trials before the Yugoslavia Tribunal. It doesn't make it impossible for the judges, but it's a challenge that they're certainly going to have to address. Well, Andre, I think I've answered all the questions. Maybe not to everyone's satisfaction, but I've done my best.
Professor, I think we can get back to the question and answer section later, because in our main conference venue, I can see Katerina Krylichenko, who is patiently waiting for the possibility to ask the question more traditional way. So, Katerina, please ask the question.
Katerina's microphone is.
We cannot hear
yes,
you.
I'm so sorry. I am located in Ukraine, so my internet is a bit off. So thank you for giving me an opportunity to ask the question. Professor Schabas, very grateful for your lecture. Professor Hopmansky, very grateful to you and to Krakow Center for International Criminal Justice for holding this important discussion and public discussion. So I am head of Ukraine Legal Affairs and Program Management at the Public International Law and Policy Group, and PhD candidate at Kiev Mohyla Academy. And my PhD thesis concerns specifically genocide, specifically pursuing accountability for incitement to genocide. And my question concerns this provision of the Genocide Convention, which allows to prosecute incitement for genocide in theory before physical violence actually happens. On practice, there has not been cases when perpetrators have been prosecuted for inciting genocide before physical violence actually happens. So my question is probably your estimations on the efficiency of this provision that before, waiting for the physical violence to happen. Thank you very much.
Yes, thank you for the question, Katerina. Well, this is one of these strange, incomplete offenses that we have, like an attempted genocide. I don't think we've ever really had a serious prosecution for an attempted genocide. Unfortunately, we get there too late. We're like the firefighters who like to prevent the fires, but we don't get there in time, and they don't come before the courts. So there's a future for it, in that if we have a clear-cut case, it of course can be prosecuted. Many domestic tribunals have incorporated this part, although I think that when one looks at the domestic legal reflection of the Genocide Convention, there are many jurisdictions have been not entirely comfortable with the idea of the direct and public incitement to commit genocide as a crime that can take place even if genocide itself is not committed, because of the danger that this can encroach upon freedom of expression and political debate. But it can also be addressed at the international level, and it means, for example, that, and I think South Africa has alleged this in its case, it does mean that even if South Africa was not successful in proving to the satisfaction of the judges that genocide had taken place, Israel might still be held responsible for direct and public incitement. This is at least theoretically possible in that case. So perhaps something more will be done with this at the International Court of Justice. The case law of the Rwanda Tribunal, I'm sure you've studied this and you know about this, but the problem with the case law of the Rwanda Tribunal is that genocide did take place. And so we don't have real cases from the Rwanda Tribunal where genocide was threatened in a sense by racist and genocidal speech, but where it actually didn't occur. And so the case law of the Rwanda Tribunal finally isn't that helpful in this respect. And also where incitement takes place, where there's incitement and genocide actually does occur, the proper label for the crime is complicity in genocide rather than direct and public incitement. And it doesn't have to be direct and public either if genocide actually takes place.
Thank you very much for your response.
I think that the first person in the queue is Damilola Akinmuagun. So please ask your question now.
Thank you very much, Prof. I'm Damilola Akinmuagun from Nigeria, but currently in South Africa. I'm a PhD student at the Krakow Center for Transnational Criminal Justice, University of the Western Cape, Cape Town, South Africa. Thank you for your very, very insightful lecture, and it is a great privilege to have this opportunity to listen to you. My question is a bit about the case South Africa filed against Israel, and I'm connecting it with, like you rightly mentioned in your presentation, about the fact that there's a special intent required to prove the crime of genocide, and that is, as put it in a category of dolus specialis or dolus directus in the first degree. Now, given the high threshold that is needed to prove the crime of genocide as stated in the Genocide Convention, in the Bosnia case, the ICJ mentioned that there is need for a high degree of certainty, before the intent, the requirement can be proved. Now, given the situation in Israel and in Gaza especially, I know you mentioned in your presentation that with some of the statements made by some of the leaders of the Israeli government, we could, have element of, the intent of that genocidal intent there. But my question is that when you compare the high requirement that is needed to prove genocide, is it possible for someone to look at it, and given the case law that we can say strict to in terms of the law as it is now, that genocide is what can be proved by the South African entourage against Israel. Now, some scholars have argued that if we remove it from the dolus directus in the first degree, but maybe put it in dolus directus in the second degree, that is knowledge that your actions will cause the destruction of those of the target group in question, that it will be more easy to prove genocide than when you put dolus directus in the first degree, which means that there must be a proof that even if that means that you must have that intent. So that my question is that in the law as it is now, can we say genocide is happening? And if not, if we look at it from the law as in terms of those direct in second degree, which is the knowledge of the Israeli government and the Israeli military that their actions are causing, the destruction of the Palestinian in Gaza. Thank you very much.
Thank you, Damilola. I think that this is. I think that at the International Court of Justice, you're into, in a way, a level of detail in terms of understanding the notion of intent that they will probably avoid. They, for example, avoided in the, as you mentioned in the Bosnia decision, they talked about a high level of certainty rather than, for example, talking about beyond a reasonable doubt. I know that at the European Court of Human Rights now, the judges all the time talk about reasonable doubt, but the judges at the ICJ, I think, have tried to keep a kind of a more, in a way, vaguer, but also a very sui generis approach to the standard of proof, and that's going to enter into also their assessment of this very challenging issue of intent. So I don't know that there's a clear answer to this, and I doubt you're going to get 15 of them to agree precisely on it, and that they will probably need to use vaguer formulations that they can all agree upon. Even the notion of dolus is a concept that's familiar to lawyers in some systems, but not really fully understood or appreciated by lawyers and judges from other systems. And I think the International Court of Justice does aspire to having more of a, you could say, a universal approach to it. So that's all. I mean, what you're describing when you talk about the second degree is just simply that they lack the intent to destroy, but they're aware that this is a consequence. And that strikes me as being, I think the line between the two of them is probably quite gray and imprecise. And often with these cases, we develop these theories like this dolus directus in the second degree, because we're uncomfortable with the proof of the first degree, but in fact, we really think it's what happened in the first degree. It's a bit like when we convict for negligence in negligence offenses. It doesn't mean that we're not saying that the crime was intentional. We're just saying that we can't be sure and we can't prove it entirely, and so we take it down a notch. But this is and that's partly the problem, as I said a few minutes ago, of applying language and concepts that has really been developed in the context of individual responsibility in domestic legal systems to the question of state responsibility for atrocities. And it doesn't fit perfectly, because we're really looking more at the question of policy. I mean, I think among the factors that I would consider in assessing the situation in Gaza is, first of all, examining closely the explanation that Israel is giving for its activities, which are, as you well know, I'm sure, the defeat or the destruction of Hamas and the liberation of the hostages, and looking closely at that to assess whether that's the real reason or whether it's simply a pretext. The same goes for self-defense, whether these are simply justifications for something else. I mean, I think, to me, I don't see a lot of evidence that Israel's actually fighting very hard to try and defeat Hamas. If they were, I think they would have a greater number of military casualties, and they don't. They have a relatively low number because they stand back in their tanks and with their drones, and they let fire. And of course, they say that everything is a human shield, and this in some way justifies the attack. So this is about examining the formal reasons that they give and the explanations to see whether they really stand up to analysis. I would think that would be an important factor. I think the other thing that is very relevant when we're talking about genocide is the fact that the borders are, for all practical purposes, closed and there's nowhere to go. And this has been a feature in other genocides, and it means that there's no alternative but destruction. And then finally, I think this idea that we know is also very widely held, certainly in the leadership in Israel, of expanding the borders of the country by annexing the West Bank and Gaza. And if Israel is to do this, it will create a larger state where Arab Palestinians will be in the majority, I think. And this is something that they cannot. It's impossible for them to accept. So all of these are factors that I think need to be assessed and balanced based on the evidence that you have as to whether that points to the conclusion that what they're really trying to do is to destroy. You know, we can do the same thing going back to the classic case, which is Nazi Germany and the destruction of the Jewish populations of mainly Central and Eastern Europe, also to some extent further west as well. You know, until 1941, roughly, it would be difficult to say that you had enough evidence of genocidal intent in the Nazi regime. It's not me saying this. This is the Israeli court in the Eichmann case said that. But you know, from the moment that they started to move eastward, partly from 1939 when they took half of Poland, but then continuing on into the rest of Poland and deep into the Soviet Union, they had just swallowed up a huge Jewish population that they had no prospect of sending anywhere, and that's where and then the logic of extermination came to prevail. So but it's a complex thing, and as I say, when we look at intent, every single individual in the Israeli leadership and in the IDF has their own intent. What we really need to do to get a grip on this is to look at the policy, I think.
Thank you. Thank you very much.
Well, I think I can see Sweetwana K ready to ask the question.
Yes, please. I actually have a question in connection with the previous one. If I'm allowed, I would be very thankful. Dear Professor Schabas, your opinions are very meaningful and I really appreciate them. And the one opinion actually which took my heart, it was that you consider that in Ukraine there is no genocide. In that context, just I think probably for other people it would be interesting to hear a little bit deeply, if it's possible, just due to time. So the first question, do you consider genocide as more serious crime as war crimes? Would it be more? So yes, the first part of my question is, would you consider genocide as more serious crime, which then we expect to see more serious punishment?
Yes, Svetlana. Is that it, or did you have another part of your question?
Yes, that was the first part. So in that context, you mentioned already that then we are talking about genocide. There are no direct evidences. So we should consider circumstantial evidence. And if to consider what happens in Ukraine, like historically, I would even mention that that we had like law on the Holodomor in Ukraine. According to that law, the Holodomor was recognized as genocide of the Ukrainian people. And the thing is, actually, I read one historical book, sorry, I can't name it now, but according to that, the situation actually in Ukraine was much more worse than on the Russia territory. So, I mean, Ukraine was part of Soviet Union, but anyway, actually on this part, situation was terrible. So that historical part is just one part of just destroying and analyzing that, and later everything was done in the direction to destroy everything what is Ukrainian. People who were speaking Ukrainian, people who they are just publishing something Ukrainian, permanently, historically, everything was under like destroying. It just needs some like historical analyze. And now what we have, like, then we are talking about genocide. So it needs specific, well, should we start with, there are explicit calls for the destruction of the Ukrainian identity, what we can support with some real facts. There are mass killings of civilians. There are deportation and forced Russification of Ukrainian children. So now we can even collect this information that on the territory which are under occupation, there are totally different methodology of explaining what happens, and like in totally different direction. And actually destruction of cultural identity, we can speak about that as well. Deliberate creation of light treating conditions. And even I know some examples in Crimea, which was occupied a little bit much more earlier. If there were some Ukrainians from Western Ukraine, they were just, sorry, I forgot this English word. So they are in dangerous for their life position because they are Ukrainians from Western Ukraine. So, and there is like, obviously the person who asked you that question, for me, that question is of a huge importance, because I also consider, I don't know what is your position, but it seems to me you should consider also genocide as more serious crime than war crimes. And it seems to me like analyzing the history, just if we are talking about circumstantial evidence for genocide, it really looks that we have genocide. It's not only war crimes. Many facts, they could be a circumstantial evidence for like supporting this point of view that there is genocide. And I know there are some publications there are professors, they have another point of view, but it seems to me that they do not analyze that like a little bit wider approach, you know, like to support that specific intent, to support that idea that this intent exists in this situation. Thank you very much. Sorry for my long question.
Well, you know, the door is open at the International Court of Justice. Ukraine took a case against Russia. They could easily charge Russia with genocide and try and fight that case out in the International Court of Justice. But I suspect that the lawyers in the Ukrainian government and the lawyers who were advising them have warned them that this would be not a simple matter to put forward. You're very eloquent in setting out the points, but I think they probably have hesitated, and you know, probably wisely so. I mean, your more general point about genocide being more serious than war crimes is, I don't subscribe to that really, because we have to look at it. We don't, you know, in a domestic legal system, we rank crimes in categories generally by the maximum and minimum penalties. We use the penalties to tell us which is more serious and which is less serious. And we don't do that at the international level. At the International Criminal Court, we have a range of penalties that apply to the most trivial cases to the most serious. And each case has to be taken on a case-by-case basis. So I think that's true of domestic law as well. If I were to ask you the abstract question, which is more serious, a negligent crime or a premeditated murder? If you look at a criminal code, you would say it must be the premeditated murder, because there's often a minimum sentence and a maximum sentence would be life imprisonment if you don't have the death penalty. Whereas for manslaughter, sometimes the sentence is simply a suspended sentence or some very, very minor, you know, as a possibility. And because the mental element is not as demanding for negligence as for a crime of direct specific intent, we also are inclined to rank the gravity based on that. But, you know, you can have a case of premeditated murder. Think of a family who have an aging relative whose quality of life is non-existent, and they get together, and the elderly relative is suffering terribly, and they decide to sort of hasten things with a double dose of morphine or something, and they put an end to the person's life. And that's a premeditated murder. That's the most serious crime possible. And then think of a mine owner who is negligent, who's out really just out to make money and to save money, and who is reckless about the safety issues in the mine, and there's a disaster, and 1,000 miners are killed. Which crime is more serious, the crime of negligence or the crime of specific intent? I mean, this is a teaching example in a way, but it's to show you that you could have crimes of war crimes. Do you hear me?
Yes, just now. Sorry.
Yes, we
can hear you.
Short interruption, but now I think it's okay.
Something came and said I was muted.
Okay.
Think of the terrible bombings that took place at the end of the Second World War of Hiroshima and of Nagasaki, or the ones in Europe, in Dresden, for example. These were war crimes. We're not going to call them genocide. Probably people have tried to label them genocide, but I wouldn't think so. They are war crimes. To me, these can be just as serious as crimes of genocide. There were many more victims than there have been in Srebrenica. We had a genocide where 7,000 people were killed, or 8,000 people, and we've called that a genocide. How does that compare with 100,000 people in Japan in 1945? So again, it's always difficult to compare these things, but my point is, it's not helpful to say that genocide is much more serious. I know that if we say war crimes are being committed in Ukraine, you'll say only war crimes, but I don't think that's the proper way to look at it. And also forget that another very serious crime has been committed in Ukraine, which is the crime of aggression.
Yes, thank you very much. I just mean that I would say that the specific intent I would consider exists. That's the thing. If we consider several options with then qualifying what was done, actually taking into account that specific, it's like a separate crime with just, which could be actually what could be qualified as genocide if we can prove that specific intent exists. So even if we are talking about same things, and it could be qualified as war crime, as crime against humanity, or genocide. So we always have to figure out if we have that specific intent. So it seems to me in this case, actually, that specific intent makes this crime more serious. I understand that punishment, we don't have this differentiating. There is no sorry, I just lost my English. So there is no differentiality regarding punishment in international law. I understand that perfectly. But anyway, then they consider just circumstances, just then they're talking about these 3 types or 4 types of international crimes. Genocide has something specific. Also, killing can be everywhere, yes, but then this killing happens just due to that specific intent that should be qualified as genocide. That makes this crime very, very specific and more serious from my point of view. And it makes sense. Yes, I think for Ukrainian authorities, it makes sense to keep that line that it was actually genocide, taking into account much more wider. Not just these events from 22, just wider, because we are talking about circumstantial evidence and they can be proved from historically. That's what I mean. Okay, thank you very much. Anyway, it was very beneficial to listen to your great arguments, and thank you very much. And I'm sorry for my long question.
We are approaching 4 p.m., at least here in Krakow. So I understand this was the last question. However, I can see that in the questions and answers section, we have 4 more interventions. So let me suggest switching to the questions and answers section for the last time. And let me ask Professor to briefly answer to these remarks.
Sure. Thank you, Andre. I see Khadija is asking, thank you for this session. One question about your statement, the fact that genocide stands on the same level as other crimes. If that is the case, why do you think that most scholars are frankly rather dissatisfied when the outcome by the court is crimes against humanity rather than genocide? Especially since Raphael Lemkin has famously said that it is the crime of all crimes. Does this indicate that genocide may be at a different level as compared to the similar counterparts? I'm just making the observation that in law, there's no hierarchy between them. In the public conscience, it's different. Absolutely. It's a bit like when the European Court of Human Rights made the distinction between torture and inhuman or degrading treatment. And finally, we realized that drawing that line is not really very productive or helpful. Listen, I just answer your point by saying that I'm going to repeat myself. I won't do that. I've already said what I have to say. Kaya Kowalczewska says that we can say that immunities are blocking the fulfillment of convention on domestic level. Well, the immunities issue has become a huge, huge issue in international criminal justice. My own feeling is that we probably exaggerated the importance of it. I don't think it's helped that the prosecutor of the International Criminal Court has almost focused his efforts on leaders of countries where there's little or no realistic hope that they are actually going to be brought to trial. And so we get into these constant debates about immunities. We find that many states don't really agree with the appeals chamber on immunities. And that's also creating tension between the state's parties and the court. I don't know if that's the most serious problem. It's an issue, but frankly, immunities are a fact of domestic law as well. There's an immunity in the International Criminal Court statute that doesn't seem to bother anyone. That's Article 26, which says that you can't be prosecuted for a crime committed when you're under the age of 18. That too creates an immunity. It's not a serious problem, and I think the fact that a few leaders can't maybe be prosecuted when they're in office, it's not the end of the world, because it's very hard to prosecute them when they're in office anyway. So that's my opinion about it. I just don't think that the immunities issue, I think it's become a big distortion to make it the central issue in international criminal justice. And that's not been so helpful. Could you please tell us how you can have your email address? Well, if you know how to spell my name, you just have to Google me and you're going to find me. Okay. My last name is spelled properly on the website. You'll find me immediately.
So thank you very much, Professor Schabas, and thank you very much all the participants for the extremely interesting discussion. And I would like to pass the microphone to Director of the Krakow Center of the International Criminal Justice, Professor Piotr Hofmański.
Well, I would like just to thank our today guest, Professor Schabas, for a wonderful lecture, and everyone for participating in our annual event. Thank you, Bill, very, very much. And before I close the session, I'd like to remind you that in a few days, on the 9th of April at 6 p.m., we are organizing a webinar with the participation of Professor Kai Ambos, Professor Michael Newton, and Dr. Gana Jutkiewska under the provocative title, "Is the Special Tribunal for Ukraine Dead Now?" In the chat on this meeting, you will find a link to register and participate in the webinar, on which I cordially invite everyone. And the link can also be found on the website of the Krakow Center for International Criminal Justice. So thank you very much once again, and see you soon.
Thank you, Piotr. Thank you so much for having me, and I hope to see you in person very soon.
Hopefully it will be the case. Thank you.